But there's a twist. Cops don't always need a warrant. In fact, the law loves exceptions, just like a gym membership you forget to cancel. So the first exception is if you consent, which you don't ever consent to a search. I don't care how well behaved you are, whether you don't have anything to hide. You just never know what cops are going to find. You never know what your delinquent friends are going to leave in your car. If cops need to search something, they can go get a warrant. Sorry, cops watching this, but you guys know how to write search warrants and go get them. So if you say, sure, go ahead, you just waived your Fourth Amendment protection. Even if you have nothing to hide, every defense attorney will tell you, do not ever consent to a search. If officers have probable cause, they can get a warrant. You don't need to make it easier for them. The second is the plain view doctrine. Hide your drugs, hide your weapons. If it's in plain view, officers are going to be able to seize it. If officers are in a place that they are lawfully able to be, so looking through the window of your car at a traffic stop, or they are at your house investigating a crime, if they see contraband, whether it's drugs or weapons, or evidence of the crime in plain view, they could see it with their own eyes, they have a lawful right to seize it. So hide your bongs, your drugs away from peeping eyes in the window, and be cognizant of what people could see when you open the door to your apartment or dorm room. No need to pretend that they didn't see that bag of mystery powder on your dashboard. If they can see it, they can seize it. The next exception occurs when there are what we call exigent circumstances. Exigent circumstances are essentially a state of emergency when getting a warrant is just impractical or dangerous or just unnecessary. The best way to remember this is exigent means emergency. An officer can enter a residence if there is, potential evidence that might be destroyed, or if there is a need for help immediately. Officers could respond to a domestic violence call and knock, and then all of a sudden they hear, someone getting beat up and screaming. Obviously there's an emergency, so officers can enter without a warrant. The thing is, if officers are looking in the window of a home and they see someone having a heart attack, this would allow them to go into the home and provide life-saving measures. Even though they don't have a warrant, there was an exigent circumstance that allows officers to override that. The next is going to be administrative searches and inspections. Places where searches are conducted by government officials, where people generally have a lower or reduced expectation of privacy. So this is going to be things like public schools, correctional facilities, and the airport. So, for example, people who are on probation or parole generally have reduced expectations of privacy, which means that officers are essentially allowed to conduct a warrantless search and seizure at any time. But remember that probation and parole are different. So if you are on probation, your privacy really depends on your court condition. So most Colorado probation orders include a search clause that allows searches based on reasonable suspicion of a violation. That means police need some factual reason to believe that something's wrong, but they can't just search you because. They need to have some articulable facts as to why you violated something on your probation. So let's say a person is on probation for a drug offense and they get pulled over for speeding. The officer runs their name, sees that they're on probation. If the officer has no reason to suspect that there's any other crime besides speeding, the traffic stop stays routine. So license, registration, ticket, done. They can't just automatically search the car because of someone being on probation. Now, if the officers smell marijuana, they see drug paraphernalia, or gets information suggesting criminal activity, that would be considered reasonable suspicion, then yes, officers can search the vehicle under the probation search condition without a warrant. Parole, however, is different. Parolees are still technically in state custody. They're still in the Department of Corrections. They are just serving their time out in the community. So this means that their expectation of privacy is very limited because they're in state custody. So parole officers and the police officers that are working with them can search a parolee's home, their car, a person without a warrant and without suspicion, as long as it's reasonable and related to the supervision. So for example, a parole officer can show up at 2 p.m. or 2 a.m. and search the home of someone that is on parole. They don't need a warrant and they don't even need suspicion, as long as it's done reasonably and within the scope of parole condition. The next is going to be the automobile exception, because your car's privacy is basically diet privacy. First, driving is a privilege, not a right. Cars are inherently mobile and they operate in public roadways, and so as a result, there's a reduced expectation of privacy. And it's possible for officers to be able to search a car, the whole car, and everything within that car under certain circumstances. This is allowed because SCOTUS, the Supreme Court of the United States, I'm going to say SCOTUS because it sounds like screw it. Anyway, has ruled that warrantless searches are allowed in automobiles because it's essentially impractical for officers to obtain search warrants for cars because they take time and cars can just drive away. So The search, though, has to be reasonable to the suspected offense. So if the officer believes that contraband is in the trunk of the car, they can search the trunk and the contents of the vehicle. But more importantly, SCOTUS has also ruled that officers can ask all occupants of the vehicle to step out of the car. We are not allowed to tell officers, no, we don't want to get out of the car. The Supreme Court has ruled that this is an officer safety concern. And so if they ask everyone to get out of the car, even if they aren't operating the motor vehicle, everyone has to get out of the car. So don't try to fight the officers on the side of the road. Every lawyer is going to tell you to fight your legal battles in court. On the side of the road is not going to be the tea. The next warrantless exception, so when police officers do not need warrants, is when there is a search that happens as a result of someone being arrested. This is called search incident to arrest. So if you are arrested, cops can basically search you and the area within your wingspan. Officers can search all of this. Because what could I do? I don't want to get arrested. Boom, gun. So in that case, officers are allowed to search incident to arrest. So within the wingspan, and this is really to prevent anybody from destroying evidence or grabbing a weapon. However, similar to warrantless vehicle searches, search incident to arrest is not a free-for-all. So for example, if officers have arrested a motorist for driving on a suspended license, they handcuff him and place him in a locked patrol car, they don't really have a lawful basis to search the entire car. The driver isn't able to access the car at the time of the search, nor can the officers reasonably expect to find evidence of a crime for which they arrested him on, which was driving on a suspended license. You already know the license is suspended. No, that doesn't make any sense. Now, if they are pulled over for a bank robbery or drug trafficking, then the search may be a little bit more expansive due to the relevant crime. So especially if officers need to conduct an inventory of the vehicle if it's going to be impounded. So there are situations where officers are allowed to search the entire car if it's relevant to the originating offense. And finally, officers don't need a warrant to stop and search you as long as they have what's called reasonable suspicion. This comes from a landmark Supreme case, Terry v. Ohio in 1968. Let's talk about this case. So essentially, a veteran officer in Cleveland was patrolling in the downtown area when he saw three men that were essentially peeping into an electronics store window. It was after hours. I think it was like 2 a.m, so it was obviously suspicious. So the officer believes that they are trying to case the place. So he stops them and he pats them down and he finds weapons. They are charged with, I believe they were felons at the time, so they got charged with they got charged with some type of gun crime, and their defense attorneys was arguing, no, the officer needs probable cause in order to be able to conduct this search. And because the officer didn't have probable cause, which is a higher burden than reasonable suspicion, the evidence should be thrown out. And the Supreme Court was like, no, if officers can articulate a reasonable suspicion as to whether they believe a crime is in progress, a crime has happened, such as the suspect matches the description, or a crime is about to occur, they can briefly detain the suspicious persons to ask questions. And then during the detainment, they can also pat down the person for weapons. However, what is important to understand is that stop and frisk are two separate processes, and a stop does not always justify a frisk. Just because someone is stopped doesn't mean that officers are allowed to automatically conduct a frisk. The purpose of a frisk is for officer safety, and it is solely for checking for weapons. It cannot be a fishing expedition. They can't stop someone and just start filling them up, hoping that they're going to find some drugs. It solely has to be for weapons. And SCOTUS has ruled that, just because someone is stopped doesn't mean that they are allowed to be frisked. And officers generally have to have additional separate reasonable suspicion that the person is armed and presently dangerous. So officers just can't always check for weapons. They need to be clear and articulate the facts that led them to believe that their safety was at risk during the stop. And so obviously if we know that this person is like a gang member or has a prior history of hurting law enforcement or has a prior history of gun charges, things like that, that obviously would give officers more reasonable suspicion to pat them down to make sure that they don't have weapons while they are briefly detaining them. Also, SCOTUS has ruled that a frisk is not just a free-for-all fill. So a frisk is solely a pat down, and it is limited to the outer clothing, and it is solely for weapons. So officers cannot squeeze, they cannot slide, grope, or manipulate items during the pat down. They can't reach into pockets or waistbands, and officers are only allowed to see something whose contour or mass make it immediately apparent it's a weapon. So if it's just like a bulge in the upper chest pocket, could be a bag of marijuana, probably not a semi-automatic. So a stop doesn't justify a frisk, and a frisk is solely for officer safety, and it is solely for weapons. Can't be a fishing expedition. You cannot conduct a frisk to see if you can find drugs. It's only for weapons, and it's solely for officer safety. Also, fun fact, here in the state of Colorado is a stop and identify state. So if the police lawfully stop you, you have to give them the ID. Refusing can make a bad day worse.